there an active campaign by the Secretary of State's office, whether it's using his own campaign dollars or using taxpayer dollars to actually campaign against a constitutional amendment? And I think that's what the citizens are concerned about.
And so I wanted to bring to your attention, Mr. Chairman and committee members, that we do have some evidence that he is, at least in the outstate area, meeting with the press and giving the press his views on the constitutional amendment, which are, as have been from the very beginning through all of the committee process, very, very negative.
As far as going on in telling people what he thought, what he thinks that this law will do, I think that that is definitely his duty. It's his duty to tell people what he thinks this law will do and how it'll affect the voting system in Minnesota.
Is it a violation of his oath of office to travel around the state being an opponent to a piece of legislation on elections that the legislature voted?
As I read, the articles that have been presented to us, one could continue to ask the questions about, where does it say this, and how do I interpret this, and clearly the question as to who is responsible for visiting the counties and explaining how this is going to work. I think we all know that that is the responsibility of the Secretary of State.
The Secretary of State has repeatedly claimed the voter ID amendment will eliminate Election Day registration, which is impossible. The voter ID amendment doesn't say anything about Election Day registration. Election Day registration is a matter of current statute, and in order to change that, it would require a statutory bill passed by this legislature and signed by the governor. I mentioned the Secretary's repeated false statements to demonstrate that he is not merely providing voters and election officials information about the voter ID amendment, but has clearly crossed the line into actively campaigning against the amendment. Minnesota majority and several lawmakers have filed suit against Ritchie for his attempt to change the title of the voter ID amendment from the clear and obvious language, photo identification required to vote, to changes to in-person and absentee voting and voter registration provisional ballots.
Chapter 211B is in part at least an orphan chapter. That is, there is no state agency, no body that answers questions or issues advisory opinions about it. If you have a problem under Chapter 211B, you can file a complaint with the Office of Administrative Hearings, and they'll rule on that complaint. And then there's some precedent for that situation if it comes up again. But if you have a question, for example, about what kind of disclaimer do I need to put on my campaign material, or can I use my campaign money for this particular purpose, there is nobody who can help you.
Would you agree that the governor's symbolic veto of this legislation had no impact on the legislation at all, the content, the title, anything, no actual impact?
Mr. Black.
Mr. Chair and Senator Thompson, I think the brief we have filed in this case, which may be discussed by later witnesses, disagrees with that, and I personally disagree with that statement.
Senator Thompson.
Mr. Chairman, thank you, Mr. Black. So you have now rendered a legal opinion on that. Do you believe that the governor's symbolic veto or veto had an actual impact upon the legislature's choice of a title?
Mr. Black.
Mr. Chair and Senator Thompson, since you have characterized what I said as a legal opinion, and you may be right, I think I better not say anything more until the Attorney General, my attorney, speaks.
Senator Thompson.
Well, Mr. Chairman, Mr. Black, let me restate it. If you stated it as an individual and not as a lawyer, then I'm interested in the follow-up to that. But you did give us the opinion on the issue, so I'm interested in the follow-up. Do you believe that the title was effectively vetoed by the governor?
Mr. Black.
Mr. Chair and Senator Thompson, in the previous answer I said I personally, and when I say personally I mean as an individual, and I'll say it again, I personally do believe that the title was vetoed.
Thank you.
Anything further?
And the people then elected him, trusted him to make sure that their voting system was fair and equal and that everybody got a chance to vote as easily as they could. Therefore, if he does make statements, I mean, it's like saying, and it's not, and I don't know that we can use the laws that say it's campaign related or not campaign related because it's not an election year for him. So he is just basically going out there and talking about the issue. And I'm sure many times it's because he's asked about his impression of the issue. If he's asked about it, I'm sure.
Although I appreciate the attempt to really bring to the committee members' attention, about the calls that we receive from constituents and individuals who are concerned about the decisions we make. I feel that this hearing started with very strong accusations based on those calls that, Mr. Chairman, you have received. I was hoping that during this hearing, we would have had the opportunity to hear from those individuals who do not have strong party affiliation about how the Secretary of State has conducted his business and how that had been really interpreted as really campaigning. I would have hoped to hear from people at the county level who are being trained on how to implement the decisions that we make here, and that did not happen today. And just for public information, I want to make sure the public know that this hearing does cost money.
First of all, in my opinion, this constitutional amendment is partisan. To begin with, but the Stearns County case was not asking whether or not the title was formed by the Secretary of State, because had that been the question, it should be provided by the Secretary of State, because had that been the question, the answer surely would have been yes, because of current statute 204D.15 that requires, not asks or says maybe he should or he could do it. It says he shall do it. So I really think if that was the question in that court case, which obviously it wasn't, then it would have been a different decision. So I think we need to be fair about this. And the the Secretary of State went through the process that it says right here in statute. He made his decision on the title, sent it to the Attorney General. Attorney General approved it, sent it back, and the law was followed to the T. So I really believe that this is an issue over nothing.
I am deeply disappointed that Secretary Ritchie and Attorney General Lori Swanson did not fulfill what I believe is their obligation to sit before the citizens of this state and answer questions. I am disappointed. I've always believed that they are better people than what they showed us today. My next action, whether it is to move forward and continue this investigation and look, will be made soon. And that could include different avenues.